Are prenuptial agreement or prenup enforceable in Ghana? Well, the answer may shock you. Kindly like, follow, and share this video to save lives. Prenup or prenuptial agreement is an agreement entered into by parties before they enter into marriage. And the purpose of this agreement is to deal with property rights, financial obligations, and liabilities that may arise in the marriage. That is to say, how property should be distributed, or how property rights are supposed to be distributed or enjoyed when there is separation, when there is divorce, or even when there is death, such that you don't enter into marriage and go with properties that someone have toiled over the years. Now, there is no express provision or express statute in Ghana that deals with prenuptial agreement. However, since prenuptial agreement is a contract, it can be governed by the Contract Act of Ghana. And this happens when the parties, in their own free will, entered into this contract. They sought independent legal counsel, they agreed, and they entered into the contract. Now, there are certain elements that must be present in the contract to make it valid. These elements are offer, acceptance, consideration, capacity, intention to create legal relations, among others. If the court comes to conclusion that the prenuptial agreement contains all these elements, and there is the absence of vitiating factors that may render the contract unenforceable, such as misrepresentation, such as fraud, such as undue influence, among others, the court may enforce a prenuptial agreement. Now, someone will say, what about Article 22 of the 1992 Constitution that deals with property rights of spouses upon dissolution of the marriage? Well, Article 22 says that where properties are acquired during marriage, and there's evidence that such properties are jointly acquired, upon dissolution of the marriage, such properties will be equitably distributed among parties. Now, that equitable distribution does not mean 50-50. It can be 70-30, it can be 80-20, it can be 90-10. Now, one thing you need to know is that there is something in law called privity of contracts, all right? The right of parties to enter into contract. And once parties voluntarily enters into contract, and there is no indication that anybody was forced, or there is some kind of unconscionability, the court is generally likely to enforce it. In fact, our court, as far back as 1983, in the case of a champion versus a champion, recognized the enforceability of prenuptial agreement. In fact, the Court of Appeal in the case of Emmanuel Obeng versus Kate Nyameche recognized the enforceability of prenuptial agreement and indicated that prenuptial agreement can be enforceable by the court so long as parties voluntarily entered into same, no vitiating factors. And when parties do that,